Um, it's my great pleasure to welcome you on behalf of the editorial board of RIA Law today. Before starting the event properly, I will just say a few words, though I think most of you know RIA Law for the moment. But RIA Law is a journal which is mostly working in the field of European and comparative administrative law, and the editor-in-chief is Professor El Antonio here today with us. And besides the journal itself, we have a series of other events that we organize, such as early career research, a forum every second year. We have a blog, and we also run these kind of discussions that we will have today. So we started these discussions, I think, probably 2 years ago, and we have held 5 or 6 of these dialogues. Some are really on the relationship between comparative administrative law and EU administrative law, somewhere on specific topics such as the Board of Appeal, somewhere more comparison between European administrative law and US administrative law. So today we are very lucky to have an excellent panel that has been put together by Carlo. So thank you, Carlo, for bringing all these colleagues today for the discussions. And we will focus on a more specific topic, which is the kind of relationship between local governments and EU law, so the highest level, if you want, and the lower level of government. And we will discuss more specifically as areas such as social cohesion, housing, especially affordable housing, and mobility in the age of climate change and sustainability policies. So what I will do is briefly introduce the speakers, and then I will leave 15 minutes for each of our speakers to present their main ideas. And then we'll have some questions, I suppose, to try to kickstart the discussions, and then we will open the floor to everybody to keep the discussion running. So we should aim at finishing around 90 minutes from now. So we are lucky to have three excellent speakers. I think first, Laetitia Diez-Chances, who is an assistant professor in EU law since April 2023 in Maastricht. She holds a PhD in law from the European University Institute, where she was an Emil fellow also at New York University, and she was inquiries officer at the Ombudsman Office before joining Maastricht University. Her thesis was entitled Integration Through Law and its Discontent, Unveiling the Distributive Impact of Judge-Made Law in the EU, and that thesis was awarded the Mauro Capellati Prize for the best thesis at the time at EUI. And her main interest is around how EU law affects the distribution of wealth, and we will have some discussions about EU funds today at that in that area. Then the second speaker will be Dion. Dion, is it correct? Dion, yes. Dion Kramer, who works as an assistant professor of EU law in Amsterdam at the Department of Transnational Legal Studies. He defended his PhD thesis on earning social citizenship, free movement, national welfare, and the European Court of Justice, which was also awarded the prize, the Erasmus Dissertation Prize. And now I think Dion's research is moving a little bit more into local regulation of cross-border platform economy, such as Airbnb, posted workers, and homelessness by non-nationals in other member states, for which he won a Veni grant to do more research in that area. And then we will have Carlo Colombo, who is a Marie Curie individual fellow at Sciences Po Paris and an assistant professor at Maastricht University. His research lies at the crossroads of public law, political sociology, and governance studies, where he looks at how government can work together across and within levels of government. So his research is mostly on law and the city and EU state aid, and he has also some recent research project trying to advance the understanding of the influence of EU legal system on urbanization processes and questions connected to sustainable transition in cities. So we have three excellent speakers, very specific and expert in local governance. So I will pass the word first to Laetitia for 15 minutes. Yours, Laetitia.
Thank you, Isel, for the introduction, and thank you, Carlo, and everyone for the invitation. So I'm going to share my slides that you should be able to see if everything goes well. Can you see them? Okay, so
yes, it is.
Play from start. If I can. Sorry. Perfect. So, as Iselt mentioned already, I work a lot on the interaction between EU law and inequality. And one of my areas of study is the use of EU funds and cohesion policy. And I thought it was an interesting counterpoint to the way many scholars approach topics related to the impact of EU law on local governance, because these discussions usually revolve around the effects of the internal market and internal market regulations. But I think sometimes we forget that the EU is not just about freedom of movement and internal market, and there are other important tools that can also shape the way people live at the local level. So I'm going to start by presenting what cohesion policy is about and why it can be relevant when we talk about the city. Cohesion policy did not exist from the very beginning of the European Union. It was established later on, around the 70s, it is said. Now it is recognized in the Treaty of the Functioning of the European Union. The reason why it got established was that in the aftermath of the internal market, when there was freedom of movement, it seems that inequalities within member states increased. And the reason for that was that with all this freedom of movement, economic activity moved to where there was already a lot of economic activity. There was an agglomeration of economic activity that meant that some territories, usually rural areas, were left behind and became less and less developed. So to counter these dynamics, a policy was established to invest in these territories that were being left behind. And according to what is today Article 174 of the treaty, the objective of cohesion policy is to invest in regions that are lagging behind and to try to soften the disparities between the levels of development of the different regions. This is done through several instruments that are the funds, the structural funds. The European Social Fund existed already since the 50s, but it changed approach. When it was established, it promoted mobility, but when they discovered that mobility was not always a good idea for rural regions, they thought that maybe the European Social Fund should also invest in creating employment in areas that were lagging behind. The European Agricultural Fund for Rural Development also existed since the 60s because it was part of the Common Agricultural Policy, but it changed approach and it started investing more in poorer regions. And the newer funds that were created thanks to agricultural policy were the European Regional Development Fund to invest in poorer regions specifically, and the Cohesion Fund. That one was created in the 90s to invest in poorer member states. So these funds were basically given to regions that were the poorest, and also areas within these regions that needed to boost employment or that needed to invest in transitioning from post-industrial to new market economy sort of employment model. There were specific ways of disbursing the funds that made them very interesting. For example, the leader and urban approaches were bottom-up approaches. So this part of the funds were specifically managed by the Commission directly with local entities, local communities that decided what they wanted to spend the money on and how they wanted the projects to look like. So this narrative of the funds up to this point supports this idea of EU law, and in this case, EU funds, giving innovative solutions and opportunities, kind of increasing the capabilities of local communities. What happened later on is that the way the funds are distributed shifted a bit. Especially since 1999, the funds started to expand the eligibility criteria also to wealthier regions. and to other types of interventions that prioritize growth, jobs, innovation, the digital economy. This was also very much influenced by the Lisbon Agenda for Growth and Jobs, but it consolidated in later budget periods. So it's something that has never stopped. It's an ongoing trend. The consequence was that the funds started flowing to wealthier areas, but also to wealthier people, because employment programs, for example, were no longer necessarily focused on unemployed individuals or vulnerable collectives. They could also fund specific courses at universities or even research projects. What also happened from 1999 onwards is that the funds became more decentralized. Member states had more margin of maneuver in deciding how they were distributed. And the observed effect was that central governments tended to shift more funding to cities and to wealthier cities, basically capital cities. And this is where we find ourselves today. There are a few controversies when it comes to this relocation of funds from predominantly rural and poorer areas to cities, and especially wealthier cities or certain sectors of activity within the city. The first controversy is why. So what is the logic of cohesion policy in the moment in which we start using the funds for these new objectives and these new subjects? The initial logic of cohesion policy was to counter economic agglomeration. That's why we were investing in poorer regions that were left behind, so to speak. But with the new logic, we're basically making cities even more attractive. Is that something that is consistent with the legal basis of cohesion policy? Because what is happening is not just that this money is no longer being used in poorer areas, but that we are actually increasing inequalities between wealthier and poorer territories. We could find somehow another logic behind cohesion policy that will support this shift, and is one in which we see the policy and the funds as a way to compensate for the inequalities that are created by the internal market. So if, for example, foreign direct investment is fostering, promoting the housing crisis because rental prices become unaffordable, then it would make sense to do as the Commission recently proposed, to redirect part of the cohesion policy funding towards alleviating the housing crisis, subsidizing rents. That could be a possible approach. The other controversy is for whom. So what is the logic economically, but also philosophically behind shifting this funding towards cities? Well, we could think that because cities have more inhabitants, investments that take place in cities, so infrastructures or programs that alleviate the housing situation of many people, are better and more optimal because more people benefit from them compared to, say, a rural area in which there are fewer inhabitants. But on the other hand, are the problems that are currently experienced by people living in the cities as serious as those experienced by people living in rural, uncommunicated, underdeveloped areas? That would be another matter to consider. Another controversy is for what are the funds being used? Because as I said before, thanks to the influence of the Lisbon Agenda for Growth and Jobs, but also because of the effects of the Eurozone crisis, the fact that wealthier member states do not really want to continue subsidizing or investing in poorer countries and poorer areas, the funds are now very much focused on fostering investments that are mostly located in wealthier areas, but also mostly benefit wealthier households, wealthier individuals, more sophisticated workers. This is basically what the green and digital transition is creating. And why the discussion opens in as much as the European Social Fund, for example, which was initially established to foster employment, but also to create social cohesion, is now being directed to collectives that are very well off, very well to do. The other issue that we should consider is to what extent are the funds nudging cities towards developing in a certain way, promoting certain type of transition and investments. Is that affecting the type of infrastructures that are being built, the type of lifestyle that is promoted, and have we thought about these sort of effects thoroughly when we design the objectives and the types of projects that should receive funding? Another interesting issue to think of with all these shifts of funding is how the funds are actually disbursed. I said before that in the 90s especially, there was a way of disbursing the funds that was very much bottom up. It revolved around empowering local communities, and it was believed that this would be the most optimal way to empower them to really solve the needs that they thought they had and solve them in the ways that they wanted them to be solved. But recent studies from the Court of Auditors, recent reports, show that there's also capture at the local level, meaning that the fact that we use the funds in a local way doesn't really mean that they represent the needs of the collectives affected by the funding. So local does not always mean better. And from that perspective, how do we really want to use funds? And some final reflections in the light of all this. Because of this shift in distribution pattern, because of these discussions on how the fund should be used for and so on, some people have suggested making urban development a specific fund and potentially one that is outside of cohesion policy because it may no longer fit the legal basis of cohesion. This is an interesting proposal because indeed cohesion policy is becoming less and less connected with poorer regions and disadvantaged collectives. But that will open a whole new discussion, which is what we want to use this fund for. Again, what will be the logic behind this urban development fund? Will it be to compensate cities for what they have experienced in the aftermath of European integration, especially internal market? Will it be something else? And with all this, I thank you for your attention, and I will stop by now. Thank you.
Thank you, Leticia. I will suggest that we move to Diane, and then we go back to your points and have questions for you. Thank you.
Okay, I suppose you can now see my slides and also hear me. So thank you very much, Yusuf, and of course, Carlo, for gathering us here, right? Talk about EULO and the city. And just to say, somehow the internet connection at my university, the Vrije Universiteit, is not always great. So maybe there's a hiccup, but let's see how it goes. So yeah, I was asked to talk about Airbnb, and this is a forthcoming paper, hopefully before the end of the year in the European Law Open. And it's basically about the relationship between Airbnb as a platform, the city, and also how indeed cities become both actors but also critical spaces for EU law. And basically my starting point, I will divide my talk in 4 parts: a prologue, 2 chapters, and an epilogue. And the first prologue is basically to kind of create a bit of theoretical grounding of my analysis. Just to say, when I'm going for a run, I actually pass by this ruin. I suppose it's a ruin because maybe you recognize the famous I Amsterdam sign, which was supposed to attract many tourists to our lovely city, the city where I live, but it was a bit too successful, as you might know. So now there are too many tourists, and indeed the I Amsterdam sign was basically taken away from the central local tourist hotspots and it's now somewhere on the outskirts where it's being used for people doing their sports. So this issue of over tourism, which is now the word that's being used, kind of disruption of the balance between, local residential living and tourists, temporary visitors, has been dominating many debates in Amsterdam. And this really peaked around 2016-17 when the issue of Airbnb kind of like put even extra pressure on this question. And this is a news article in which it was basically published that there was a company who wanted to buy up basically all the apartments in all the buildings within one neighborhood to make it an entire Airbnb neighborhood, to go for the first Airbnb neighborhood in the historical center of Amsterdam. So this obviously caused some outcry in the city. And this led to the moment in which Amsterdam, I think it was in 2021, announced that it would actually completely ban Airbnb in some of the central neighborhoods of the city center, which obviously led to a lot of debate and some lobbying and all kinds of experts, talking about to what extent, a ban would be beneficial or not to the city. But it's really been a very predominant theme in our city. For me as an EU lawyer, it became especially interesting when around 2018-19, the city mayors basically said that EU law was actually preventing the city from effectively regulating Airbnb, citing all kinds of neoliberal European rules. And together with some other cities, in a coalition of European cities, the city of Amsterdam published a press release before the actual judgment of the Court of Justice in the Airbnb Ireland case, so after the opinion by the Advocate General, basically claiming that if Airbnb would be classified as an e-commerce provider under the e-commerce directive, this would have devastating consequences for the city. And well, I'm not going to cite everything, but basically the claim was made that indeed this would pose a real threat and cause risks for the social and livable configuration of our cities. So really relatively serious words when it comes to how EU law and especially the e-commerce directive would influence the way in which cities were able to create, a social infrastructure for their inhabitants and would undermine the capability, the capacity of cities to regulate the city itself. So to come to some theoretical reflections, I think it's interesting to look into the platform economy, of which Airbnb is obviously part, to an upstream and a downstream segment. And I have this clue from Advocate General Bobek in his opinion in Kali Apartments. So what's upstream? Basically, that's what big tech does, matching economic actors, businesses, and consumers at a digital marketplace. Let's say Airbnb, Booking, but also other tech companies. And downstream are the actual underlying services which are being offered. So for example, renting out an apartment to a tourist. That is the underlying downstream activity. And what I find interesting is how these different kind of levels of the platform economy are interacting and how EU law structures this conflict. And how it does so is by means of the e-commerce directive when it comes to the upstream market, which is of course partially replaced by the Digital Services Act by now. And in the downstream market, many services are covered by the Services Directive. And this also applies to the short-term rental markets, right? So the Airbnb market, so to speak. So in the remaining 10 minutes, I will use some snapshots from the case study I did with respect to Amsterdam. So I'll give some examples, but this is definitely not comprehensive, right? So just a couple of examples I will use from this case study. Let's start. Chapter 1, how to regulate Airbnb downstream. I'm not going into all the details of the law, just to say that the Services Directive, of course, requires authorities, including local authorities, in case that they want to impose an authorization scheme for services, that they have to come up with an overriding reason of the public interest. And also, of course, the proportionality principle applies, both with respect to the scheme as a whole and with respect to the specific conditions attached to the issuing of a permit or an other kind of authorization. So the Kali Apartments case is very key here, I suppose. And basically here, Paris required all the property owners who wanted to rent out their properties for more than 4 months a year to basically offset this kind of activity by buying up basically property somewhere and convert it into housing in order to kind of offset its conversion of residential property into tourist accommodation. So this requirement was being put to test before the Court of Justice, and the Court of Justice in the Kali Apartments case basically gave quite some leeway to local authorities, saying that an offset requirement is a suitable instrument for pursuing the, I'll put you away because otherwise I don't see it, for pursuing the objectives of socially diverse housing on territory, a sufficient supply of housing units, and maintaining rents at an affordable level. And in terms of proportionality, what I found particularly interesting in the Kali Apartments case is that the Court of Justice really appreciated the kind of particular knowledge that local authorities might have, because they are in a position to use objective evidence to see if an offset requirement is an effective response to a shortage of affordable residential housing at the level of the municipality, the district, or even at the level of the neighborhood. So in a way, the court gave quite some leeway to regulate Airbnb, you could say, in the downstream market to local authorities. And to look into Amsterdam, what happened there is that already in 2014, Amsterdam prohibited its basically property owners in the city to rent basically apartments out for more than 60 days per year. I'll come back to this later on. So, and then we go to the upstream market, and there we see the e-commerce directive, which was adopted in 2000 when the internet still looked like this Yahoo screen on the right. And basically what the e-commerce directive did was to stimulate internet and the free movement of electronic commerce. Well, what are the techniques? Basically you could say, a very strong form of free movement, home state control and mutual recognition. Airbnb is based in Ireland, and therefore it's subject in principle to the rules and enforcement techniques of Ireland. And there are so-called safe harbor provisions. In principle, platforms have limited liability, and also they're not supposed to systematically verify if all the users on their platforms are actually complying with national or local rules. So this is the prohibition of general monitoring that applies to them. Well, and obviously the main question was, does Airbnb qualify as a e-commerce provider? And the court said so in Airbnb Ireland. In contrast to Uber, Airbnb can enjoy those liberties. Well, a snapshot from the case study is the following, that aware of the e-commerce directive, the city of Amsterdam basically signed a memorandum of understanding with Airbnb, which was based on a voluntary cooperation. Airbnb would inform its hosts, its users about some of the local rules, and it would also transfer some tourist taxes to the city. Amsterdam wanted to go much further and actually require Airbnb to enforce its local rules, but it was not able to go so far. Basically, that the e-commerce directive acted as some sort of like shadow in its negotiations. So a memorandum of understanding as a form of urban governance was definitely influenced by the prevailing EU legal framework. So going a bit ahead, 2016-17, the issue of tourism really became a big issue of local politics. And the city council really pushed the government to come up with stricter rules. So there was an Airbnb ban in a couple of neighborhoods in the city center. Properties could not be rented out anymore for more than 30 years per year. But let's focus on that ban in 3 neighborhoods, because obviously Airbnb mobilized some local action groups and they litigated on the basis of the services directive. And here we really see this idea of the city influencing, limitations to the, you could say, internal market freedoms. And according to Amsterdam, the government, the ban would restore the disrupted balance between residential living and tourism and protect residents against the bustle and nuisance caused by tourism in their direct living space, in the hallways, the gardens, and on the balconies. But after a couple of years of litigation, the Council of State finally found out that in principle it's okay, to protect residents against over-tourism, but it was disproportionate. And what was interesting here is the first time the council starts to see, short-term renting as a service under the Services Directive, whereas before it was simply not seen as such. If an apartment was classified as residential living, it was simply prohibited to rent it out to tourists, because that would classify as a hotel service and be outside the scope of, a certain zoning strategy. So EU law in a way facilitates the reversal of the status quo at the local level. Okay, how did Amsterdam move on? Of course, Airbnb was not so happy with these new and very strict rules. So Airbnb decided to not continue the memorandum of understanding. So what did Amsterdam do? They started to lobby the national level. And they basically asked the government to come up with obligations for the platforms, including Airbnb. And it was basically only because of, you could say, a very weird cooperation between a socialist member of parliament and a liberal member of parliament, who both had some sort of interest in actually enforcing obligation on platforms, that a new act was adopted and that Airbnb was basically forced to display registration numbers. This was a big dilemma for the government and for the specific ministry, because under the e-commerce directive, this meant they had to notify the European Commission and notify Ireland as the place of establishment of Airbnb that they would use public policy. That was the only possibility, public policy, as a justification for imposing obligations on a platform under the e-commerce directive. So this forced the government to basically justify it, that the large-scale use of residential properties to tourists via online platforms seriously affected the livability and safety in certain urban areas and exacerbated problems related to the supply and affordability of long-term rental housing. And this should be classified, according to the government, as an issue of public policy. However, it's very important to see the effects of this. The Airbnb Act was adopted, and from the moment onwards that the platforms were obliged to only advertise properties that were properly registered with the municipality of Amsterdam, we see a drop in the number of advertisements that's absolutely stunning. From 18,000 advertisements Airbnb, it went down from one month to the other to 3,800. That was only because the platforms were obliged to, to stop advertising those without the registration number. And then I finally get to the epilogue. I have 1 minute and a half left. And so what I've been talking about is that the city of Amsterdam was trying to influence, the way in which property owners were renting out their places to tourists. They had to lobby The Hague. Here you see The Hague, that finally was able to impose obligations on Airbnb, had to correspond with the European Commission. The Commission was basically was silent on the issue, did not put up any protests with respect to the rules imposed by the Dutch government. But what I want to address finally is that Eurocities, Amsterdam and other cities joined together and lobbied the EU institutions, including the Parliament and the Council. And in addition to the Digital Services Act, they adopted a regulation on data collection and sharing rent relating to the short-term accommodation rental services. And this, what I call the short-term rental regulation, was designed, and here this I find interesting for the talk of today, to enable cities to design and implement policies and exercise their competences to address the concerns of local communities related to affordable housing and balanced tourism. And how this works is basically by putting a similar kind of obligation on platforms, as we have seen already with respect to Amsterdam, that websites should force hosts to advertise with a registration number. And also the platforms are now required, at least not now, but only in 2026, to share their data with public authorities. However, cities, if they want to regulate, Airbnb and other platforms in this way, they do have to comply with the requirements of the regulation if they want to set up a registration procedure. So there's a form of downstream harmonization, but there are upstream obligations. And, so what I find really curious about all of this is that cities become not only places where, urban conflicts are being structured by EU law, but cities themselves become active actors in the process of European integration. And I've already talked too much, so thank you very much for your attention. Yeah.
Thank you very much, Diane. It's really super interesting to try to see how the EU is called upon, while actually it's for local government to just be able to exercise their own powers that they may be able to have from constitutional law, or in certain countries at least it may be the case. So that's really interesting to see the web, and also that Ireland is brought in the picture. Why, what can they do about what happens in Amsterdam, for instance? So that's really interesting. We probably will discuss that a bit more during the discussion. Please, Carlo, if you want to share.
Yeah, there you go. Do you see it? And can you hear me well? Okay, well, thanks a lot. And thanks a lot, of course, to Hizul and Marielena for making this possible. And thanks a lot also to the other two speakers also, because I think my presentation will try to sort of link up with the other two presentations before. So I'll develop the presentation along three main steps. I'll first say something about my project and then dig deeper into a case study of urban mobility, and then wrap up with some sort of closing conclusions that hopefully will kickstart a lively discussion thereafter. So my project starts from what pretty much the other speakers have already introduced, right? So cities are on the rise, they're becoming extremely more important among other institutions and spaces within the European Union. That's due to economic, societal reasons. The vast majority of Europeans live in cities, and of course, lately for environmental reasons. And that has two main effects. That is also due to two main processes which are connected to well, sort of globalization. On the one hand, pre-territorialization of many of the sort of strategies by the main actors, but also the decentralization of powers at the local level. And this is making the city like taking the initiative on many issues, including Airbnb or European funding. This is also having like two important effects when it comes to policymaking. So we have European Union law increasingly being involved in solving these urban conflicts, because of course, I mean, this rise of cities is matched with a number of challenges connected to environmental challenges, societal challenges, economic challenges involved. And at the same time, we have urban actors, not just cities, but actors within cities, as I'll discuss in a moment, that are sort of rescaling their strategies at the European Union law. So my question is to make sense in a way of how EU law is influencing and shaping the urban society more in general, and the powers of cities to govern this urban society. And on the other hand, what does it mean for looking at the EU and the development of the European Union from the local perspective? And what I try to do is to look at the city not just as an institutional actor, as it has been traditionally done by constitutional lawyers, in a sense that the main question is what cities can do within the European multi-level constitutional system, and not just as cities, as social spaces. So looking at what the law contributes to shape, how the law contributes to shape society within Europe, but I'm looking at cities borrowing from the sociology of governance, cities as collective actors and incomplete society. Collective actors mean I look at conflicts and the way conflicts within society and dynamics shape the regulation within cities. That is the traditional model of how cities have been regulating for a long time. And that's the perspective more from the what you might call the Weberian understanding of the city. Incomplete society is the way the society nowadays works, with certain actors being able to rescale their strategies across different levels due to their characteristics and their powers. So you see increasingly a possibility for certain actors to rescale the regulation of certain problems and the solution to these problems, this time at the European Union level and no longer at the local level. So in other words, I'm looking at how the regulation of the regulatory framework of cities is being transformed in a context of European Union in the Europeanization process. So I'm looking at the Europeanization of urban regulation, and on the other hand, on a critical analysis of European Union law. As I said, my main focal point is being mobility, which is at the core of what, of course, a city is, because it allows people to move around, but not just people, but also goods, companies within cities, but also outside cities. But mobility is itself part of the core principles of European Union. And nowadays, of course, mobility is very much on top of the agenda of various levels of government because of its implications and its transformations, which are triggered first by certain transformations within society, but also in order to achieve certain goals set, and particularly a sustainable goal at the local level. But the other characteristics of this, and that's my interest in my research, is that all these transformations or transitions are conflict-ridden. So they are highly polarizing within cities, with And therefore, I'm looking at how actors mobilize, organize in different societal actors, and therefore influence how the regulation across various levels is created within cities. And I focus specifically on 3 different elements of or components of the city. So the market organization of the city, which I'll discuss in a bit, the environmental or sustainable element of mobility, so the transition away from a car-dominated mobility towards a more sustainable level, and what Letizia was mentioning before, so more the funding, the infrastructural creation of mobility, of course, in a bilateral way. Now, let me start from the first part. So I'm looking particularly in my research at the market of taxi services. Taxi is a quintessential kind of transportation within cities, and normally it is organized around 3 main actors within the market. You have regulated taxis, which have certain advantages. Therefore, they can, for instance, apply for hire, so they don't need the requirement of a reservation before in order to be used by the users. But at the same time, they have certain obligations. So the price is normally set, and they have to they have to bring like the user to the destination they want to. And then you have PHVs, which are normally like run by companies in a free market, and then you have the necessary intervention of the intermediaries to sort of match demand and offer of transportation, non-public services on demand within cities. And the characteristic of this market, like many other markets within cities, including also housing market and the market for tourism facilities, is that normally full competition doesn't hold in all these markets, and there are a number of externalities within this market that has to be regulated. So in other words, it is a market with high level and a high density of regulation within the market, and therefore you have like always this dynamic within the regulatee and the regulators always interacting together in order to shape the regulatory framework in ways that can solve the various tricks. And the main issue here, as I said, it's full competition, because there is a high mismatch between on one hand the demand, and on the other hand the offering of transportation services within cities. So you see, in a way, the law as a necessary instrument to shape markets, but also in a way, and sometimes that's the case in many markets, law as creator of inequalities within the market. And therefore, there is a need to sort of solve this inequality. Now, the characteristic when it comes to the, if you wish, the political economy of this sector are at least 2. On one hand, there is a large variety. So despite the market being sort of in need for regulation, you have a large variety of taxi regulation all across different cities. This is just a summary. The system is much more complete, but therefore you have different ways of regulating, with markets which are much more liberalized and others which instead have, like Spain or Italy, a very highly regulated system, which sort of try to combine and interconnect the various actors within the city. The other characteristic of this market, which I wanted to point out here, is that for a long time, this market has been outside of the influence, despite being ripe with many restrictions which irritate the internal market law. It has been outside of the influence of European Union law. And that's due to, on one hand, the characteristic of that market, but also the sort of peculiar distribution of competencies within the market. Here are just a couple of cases where PHVs and illegal taxis have been trying to argue for the application of European Union law, and a court of justice rebuffing these attempts. This has, as much as in the Airbnb case, where we have seen, as Dion said, the sort of Europeanization of part of housing regulation by the European Union, you have the same sort of effect within the mobility market, even though it has developed in a slightly different way. So you have clearly the emergence of digital transformation has changed the dynamic within the market. And by changing the dynamic of the market, it has changed, first of all, the local regulatory framework within the various actors being involved at that market. And some of the actors, in this case platforms, have been able to manage, in the idea of the incomplete society, the involvement of the European Union through the Service Directive. I'm not going to go into details in these two cases because I assume they are quite well known, and Dion has already mentioned part of them. The conclusion of the two cases by the European Court of Justice that Uber is not just an information society service. It is in fact part of a broader service, being it a transportation service, and that's because of it creates a entirely new market, and also it exercises the decisive influence, influence being a concept derived from competition law and labor law in order to sort of find a connection between the two different actors. And therefore, since the principle governing the freedom to provide services is not regulated by the European Union through a common transportation policy, this has realized the power to regulate taxi market within the local authorities. Now, this case is very important for many of the reasons that we've discussed also in the previous presentation. Literature has so far focused on a couple of things. I think something is missing in their understanding. So first of all, they've discussed the interpretation of what is an information society service, also questioning whether it can be and to what extent it can be expanded to other services. But also the other interpretation has been understanding this case in terms of realization of competencies at the local level, and therefore to the advantage of certain actors within the market, typically taxis, which are considered to be sort of quasi-monopolies, at least in certain markets. So in a way, that's the interpretation which echoes sort of, although in an opposite way, the traditional understanding of internal market law as having effects on the society which go into the direction of completely deregulating and disembedding the market from society. That's at least the traditional understanding. Or if the Court of Justice realized to the local level to the advantage of local authorities. My understanding is that this is not a complete reading of the two cases. In fact, when you're talking about cities and when you're talking about urban markets and the way the two levels interact, it is much more fitting to understand them as a co-evolving kind of markets which evolve in connection with one each other, with the European Union and European Union law having a function of market structuring instead of fully deregulating or disembedding the internal market from the law. And just to give like some sort of a reflection to kickstart the next one, I'll delve deeper into a couple of cases that followed up this previous discussion by Uber. The Star Taxi app, and the next one is the case of Taxi in Spain. Star Taxi app is a case that is quite important because it follows the Uber case. It is about a Romanian-based app whose business model is pretty much built around the business model of the decision by the European Court of Justice, because it tries directly to bypass any limitations, so not to be considered for the dispatcher, not to be considered like a transportation company, and therefore enjoying like freedom of movement within the European Union. And that transportation app has been imposed right after the Uber case, an obligation by the city of Bucharest, clearly in order to limit its innovative business model, because it imposes to this dispatcher the obligation, despite it being functioning as a digital app, the need to have employees who can communicate directly to the taxi driver. Now, this decision has been very important because it goes back to Uber Spain, and it clarifies also what is the meaning of a technical regulation. But to the present sort of discussion, I think it is very important because it shows something that goes a little bit against what is the mainstream idea of EU internal market law. Well, it's true that EU internal market law favors certain actors and promotes sort of some deregulatory intervention by the European Union law, but that is not always, that is not the full case. Here we have like a Romanian-based app, which doesn't have any sort of a transnational business model in that respect, and doesn't exercise any influence on taxi drivers. And despite this, the Court of Justice concludes that it enjoys the freedom of establishment, and therefore it doesn't any limitations and any restrictions to that company cannot should be proportionate as in the normal kind of balancing way in which the European Union law intervenes. The second element is that also dispatchers are nowadays under the sort of approach and the influence of European Union law. And the third kind of observation, which I think is quite important, it's that despite the general mainstream understanding of EU internal market proclaiming that EU law does have any deregulatory or otherwise completely like safeguarding local authorities effect, instead here you see like the possibility of promoting a more liberal market, but whilst at the same time keeping the possibility of regulating markets. So if you, in other words, reflect on the effect in terms of interest and balancing of interest and discretion being left at the local authority, that's still quite a broad one. Local authorities can still regulate dispatchers, but this regulation must be fit for the objective for which it has been put in place. The other case, which came out like last year, it is about, again, a very densely regulated market, the Spanish market of Barcelona, where the city has introduced like a dual licensing system. So in a way, the city has introduced an additional system for licensing PHVs, which provides not only a license, but also a limitation, a numerical limitation on the licenses, which is capped in a ratio, creating a ratio of 1 PHV license per 30 taxi licenses. So in a way, it is clearly to safeguard the monopoly of taxi drivers, being them a very important actor within the European Union. What is within the market of Barcelona? What is the implication of the intervention by the European Court of Justice? Well, you see here again that urban taxi schemes are in a way also subject to the intervention of European Union law. So unlike the general interpretation of Uber Spain and Uber France as sort of reterritorializing the power of regulating the market is much broader and much more multidimensional, and therefore all elements can call into question the application of EU law. And that's also because in that specific case at issue, there was a transnational company that was one of the party in one of the cases that led to the intervention by the European Court of Justice. If you also look at the way the European Court of Justice has sort of interpreted the interest at play, you see that definitely there is the possibility for local authorities to intervene. It is true that this scheme has been struck down for at least one part, but the Court of Justice said, well, there is a possibility of having a specific licensing system for urban areas, provided that, of course, control is not duplicated. And there is indeed a possibility of regulating taxis The only problem is that in that specific instance, it was the ratio that was inadequate for achieving, so not appropriate and not necessary for achieving the objectives. So in other words, you have still the possibility of EU internal market law through the intervention of these conflicts of cities to re-regulate the taxi market within a local market in ways which are not necessarily the regulatory, that can benefit also local and smaller players, and that at the same time leave quite broad discretion to the local authorities to regulate. So just as a sort of a wrap up, I mean, as I said, I mean, the case study is a little bit more complex. I think that in my understanding, the relationship between EU law and cities is not just like a one-way regulation. It is more sort of a better understood as a iterative process of mutual co-evolution. So in a way, you have like EU law entering, but also the local law giving shape to this law, because ultimately what you see happening at the European Court of Justice are restrictions being reinterpreted and reassessed in light of EU internal market law. So social conflicts are essential in order to reform this European Union law and to create what I define as city-specific laws. And this result of this city-specific law is in a way to re-embed and to reconnect EU internal market law to broader societal goals. And also, if you look at the way interests are sort of allocated as a result of this intervention, in this case by the Court of Justice, but it can be also intervention by the legislator or the European Commission, the European city-specific rules do transform urban regulation, but they do not always, and oftentimes it's quite the opposite. They do not produce like fully either the regulatory effects or fully like reterritorializing effects, which bring the power back to the local level. But it's more like a pluralist view of market where different actors have their own role and can operate in a sort of a liberal market to achieve their own goal. And this also leaves to the local authorities quite broad possibilities to achieve their own goal and to regulate again this market. That was it, I think, for me.
Thank you very much, Carlo, for your very extensive explanation. So I think we had three very complementary speakers, and we have moved a little bit, dreaming of Paris, Spain, Barcelona, Bucharest, and Amsterdam. So thank you for the trip around Europe. These discussions, I think, gives us interesting insight into the spatial dimension, especially the local spatial dimension of the freedom of movement, and maybe also the possible abuse of this freedom of movement. Nobody mentioned abuses as such, but when we talk about over-tourism, it's a form of abuse, or we can see it in that way. So this special dimension that you have highlighted in various ways emphasize, I think, the possible risk of inequality or conflict across the whole of the EU, as it was the case in the first presentation, across member states themselves, and also within cities. And what was also very interesting in the last two presentations, within cities as neighborhood or specific parts of the cities in and of themselves. So this needs you, and I think it came back in a number of presentations about the discretion of local government to do certain things or to take actions and initiatives to deal with the specific issues they are dealing with, to try to develop a balance, a discretionary balance, sometimes embedded in some test of proportionality between policies, between different local interests. And I was really struck, and I think it's super interesting to see that local government are using things like registration number, banning some activities, but also taking innovative approach like the dual licensing regime that we just discussed. For me, this is also creating some kind of scarcity in the market, and it's also leading to some discussions about how we allocate this kind of scarce good at the end. So the question is really, we have scarce goods in licensing, we have also scarce money in many ways, and the question is, all local government can take the initiative to attract investment, but the kind of investment that they want and they need for their own local objectives. So I will just pause there because I don't want to monopolize stuff, but I have like a couple of questions, and maybe I can say my questions, leave you to think, and we can open the floor, because otherwise there won't be much time for colleagues to ask their questions. But my first question is that my sense is that in the three presentations, the notion of competence came across very clearly in terms of, you know, Laetitia, when you were discussing affordable housing and saying that EU money would be directed to support affordable housing. I'm just thinking, well, on which legal basis can the EU do that? I mean, you will say about the cohesion, on the basis of cohesion, but if there was not that legal basis, would affordable housing be something for the EU in some ways? Isn't it some kind of competence creep, or maybe it does not fall really within the technical notion of competence creep, but it's still, I think, taking decisions at a local level, or supporting certain type of policies at local level in an interesting way, maybe a very extensive way. The same thing with the short-term regulation that you mentioned, Diane. And I'm sorry, but I come back to the last slide of one of the very last slide, the fact that the EU is saying local government can take initiatives and policies in their own for their own interest. It seems to me kind of a form of strange extension of what the EU is doing in that way. But maybe not, maybe there's a good reason. But for me, it's still striking that the EU does that. And Carlo, you also mentioned things about the Uber cases and the co-evolving market ideas. It's something I'm not sure I fully understood. So maybe at one point you can explain a little bit more this notion of co-evolving markets. And then overall across the three, but as I say, you can think about it, and we can first hear from the other member of the audience. But how do you bring some kind of interdisciplinary methods in how you approach these questions that you mentioned? Because there's obviously the legal aspect, but there are also economic aspect, there are social aspect. So what kind of specific kind of approach do you use? What kind of of tools do you use to combine these insights from different disciplines? And I would be very curious to know a bit more about it. So thank you very much for your presentations, and I will open the floor to colleagues. I suppose that over-tourism may talk to Stephanie, for instance, and maybe you have questions. Not putting too much spotlight on you, Stephanie. Any questions from the audience? Any questions among the speakers between themselves? Yeah.
Thank you very much for three very interesting presentations. And I have to, I'm Jane Reicher from Stockholm University, and Stockholm being up north, a bit on the outskirts of the EU. We don't have a big problem with over-tourism yet, perhaps. Let's be hopeful or not. But I don't really recognize the situation you described from Sweden, the Swedish context, which may again be that we're a bit on the outskirts, or that I have missed this. But I was thinking that an issue that was discussed quite a lot in Sweden is, this is also, we might be a bit behind also here, is the EU agricultural rules, and also fishery, which has been both this and perhaps also regulation on forests, relating to environmental issues. So this is much more rural and countryside issues that have been much more in the debate here in Sweden. So and this is of course a very traditional question where the EU within agriculture and fishery especially have been quite, I mean, there are a lot of case law from the 60s and 70s on that these agricultural regimes were interfering with the human rights. We know the International Handelsgesellschaft and so forth. So this has been a traditional clash between EU regulatory regimes and the national, more local national traditions and so forth. So I was thinking a bit, but this might be like a new era of similar issues, but within a new type of framework. And so I was thinking, I don't know if you agree with me, but from this first premise, but then also this is what you're presenting is much more diverse, and the regulatory tools used and described in your presentations are more diverse than perhaps now when I'm kind of taking a very general point of departure here, but as far as I know, at least, the fisheries and agriculture are more set in a certain way, and there's certain tools. But here there are internal markets, there are these different types of aid and so forth. It's much more difficult to see this is the EU policy for cities, if you could put it that way, compared to this is EU policy for agriculture. So I was thinking a bit how, if you would want to, as a citizen of a city, and you want to, understand how EU law intervenes with these local questions. Do you see that as a problem? And I asked the question to all three of you. I don't know how you would like to answer, but how does this mean from a local democratic perspective? I'm thinking of that the Council of Europe, for example, has this convention on local communities and local municipalities, and the direct democracy, or not direct democracy perhaps, but the local democracy and all these. How does these ideals come into play if you understand what I'm talking about and have some reflections on that? And I don't know if I should point to someone, but any of you could discuss this. Thank you.
Oh, sorry, I was muted. Thank you to Rachel. I think it also goes back a little bit to my question of local competence.
Yes. I was thinking about that. You inspired me.
Yeah, I don't know who wants to answer Jane's point.
And I'll start probably.
Yes, please do.
But then, yes, and then of course my colleagues will continue. So I think indeed it links with Isel's question, Jane and Isel's question on distribution of competencies and who is doing what, how, when. So the preliminary remark is that indeed with the common agricultural policy in the 60s, 70s, 80s, still part of the 90s, the EU had a very strong role in telling member states and below member states what to do, telling farmers how much they should produce, how much money they will get. But the system changed. And now the system is becoming more similar to how the structural funds in cohesion policy work, in the sense that in the past, common agricultural policy was based on setting minimum prices, so intervening in the markets directly. But in the early 2000s, they transitioned towards a system of payments, meaning that now the EU is giving payments to member states and then to farmers in exchange of, engaging into a number of practices. And the reason why agricultural policy and cohesion policy have become so similar in the way they work is this process of decentralization or shared management. That means a shift of powers and tasks to the member states, or sometimes regions, local entities, to decide how they want to spend that money. And in the case of agricultural policy, even how they will define the environmental conditions that will be imposed on the farmers. What does that mean? It means that indeed it's becoming more and more difficult to understand also in agricultural policy how the money is being spent and what the real goals are, because even if the regulation says these are the objectives, these are the conditions, then member states have a really wide margin of maneuver in making those objectives and conditions specific. So many of them are really getting away with not complying with the agricultural environmental conditions, for example. And in the case of the structural funds, many member states are getting away with redirecting the funds to very wealthy areas. Now, how does this affect the division of competencies or who is doing what? Indeed, I think this is the consequence of the EU trying to cover more things on which it would like to play a role. The price to pay was that indeed, not to be intrusive with national competencies, then the EU had to put up with giving member states more margin of maneuver in how they will spend the money. So with the housing crisis, for example, what I assume is that the EU will give member states money saying, okay, the condition is that you have to spend it on solving the housing crisis, but then it is for central governments or regional governments to decide specifically how they will tackle the housing crisis. And many of them maybe use the money in ways that are not really conducive to softening the housing crisis in areas that need it the most. That's a problem. So there is this tension between national competence or national sovereignty and EU goals. We usually assume that the more the national, the better, or the more local, the better. And as I said before, that doesn't always lead to a more progressive result, to shifting money to collectives and territories that need it the most, because also at the national, infranational, sort of regional, local levels, there are groups that can capture that decision-making process and end up shifting the funds to projects that maybe are not so relevant from a cohesion point of view, or to collectives that basically don't really need funds because they're already quite well to do. That was it on my side.
Thank you, Laetitia.
Yeah.
Hello, Diane, do you want to react, to add something?
Yeah, I can continue indeed, because I'm coming more from the perspective of the internal market indeed. So yeah, I think the issue of competence is, I mean, the entire story that I told and the work that have been written can be completely rewritten from like a perspective of, you know, a clash of competences indeed. But I think the issue here is that indeed the EU decided in the year 2000, you could say, to almost completely harmonize rules with respect to e-commerce providers without knowing, you know, of course, not being able to grasp to what extent the platform economy would come to dominate so many aspects of, you know, the economy and society more widely, right? So, and every time that indeed a certain aspect of society or economy is captured by platforms, it means that somehow the e-commerce directive starts to play a role here, and the Digital Services Act now, you know, starts to play a role. And basically that decision has been made by the legislator, that is the, you know, the EU level is the level where administrative and more enforcement actions are being predefined in a way, how they should look like. So, and here it comes indeed that when a city wants to regulate, let's say, its housing market, or wants to regulate, you know, aspects related to, I don't know, cruise ships, for example, you can think about it, you know, every time that those aspects of the economy are also have an upstream dimension, right? That's why I think it's so useful to think about an upstream dimension in the platform economy. You know, they're bound in their enforcement tools of what is possible by EU law. And that's, I think, where the clash of competences comes in, and why it's so interesting to think about, you know, this new regulation, the short-term rental regulation. The only thing it does is a plug-in to the e-commerce directive, saying, you know, the only thing that, you know, platforms now have to do is to enforce, you know, a registration number and to share data with the public authorities. It's not doing much more, but it's a crucial aspect, because without it, cities indeed are not able anymore to effectively, okay, I'm you know, simplifying a bit, but like they are no longer able to enforce their own policies with respect to, you could say, their competences when it comes to housing policy. However, it's a much broader story, because also the Services Directive is kind of reshaping, you know, the relationship of housing regulation, because now it, you know, the Cali apartments, of course, gave a lot of leeway, saying, you know, it is indeed, you know, member state authorities, especially cities, can regulate short-term rentals. However, it is covered by the liberal proportionality principle. And that is, and now I'm going to Jane's point about, the citizen and information. And, indeed, it's true. It's now the relatively abstract norms from the e-commerce directive, the services directive that are coming in and are being used by private litigants and are being mobilized against their city governments. There's a whole range of cases before the Amsterdam courts about all the fines that have been imposed by the city, and it's all about proportionality, but that has to be defined by national courts and finally by administrative authorities. So indeed, I think Carlos' point, about how social and economic conflict is shaping EU law that's the process that we're seeing here at the local level. And final point about the case study and the tools, how I read your question, Iseult, about multidisciplinarity. My approach often is to use interviews. And I agree the challenge that of, to what extent, for example, in terms of urban governance, the decisions that are made by local authorities and national authorities, there might be economic reasons. But I'm looking for the legal reasons to do and act in a certain way. And I very bluntly ask my respondents to say something, It can be a question as blunt as this. Without the e-commerce directive, would you have chosen for a different enforcement technique? And they will say, yes, no, without the e-commerce directive, we would have done it, of course, in this way. And there I can try to see like how EU law is influencing decision-making. But obviously, lobbying, socioeconomic power plays a big role, and that's often difficult to see to what extent, arguments related to European Union law are used as a scapegoat or as used as justification, or actually other interests are at play. And that is a very challenging thing about this kind of like interdisciplinary research. So I wanted to give one example. The extent of lobbying Airbnb has been put behind, going against national regulation is incredible. There have been, before the National Airbnb Act, adopted by the national government was enacted, there have been 8 meetings between the minister and Airbnb representatives. That's just, it's difficult to even, to digest how many times it is in the busy schedule of a minister. And to what extent then in it EU law plays a role in kind of legitimizing the arguments made by Airbnb. That is a very fascinating question. And that's, empirical research can come quite far, but it's very difficult to really pin it. These are just some reflections to the question. But thank you so much.
Thank you very much. It's really interesting. We want to dig a little bit more into your answer. Thank you, Diane. I think Stephanie has also raised her hand.
Yes, thank you, Iseult. Thanks to the 3 presenters for their excellent presentations. I really think this is a very topical issue that we're discussing here. I have a question for Dion. As Iseult already suggested, I'm currently developing a research agenda on sustainable tourism. And one of my PhD students, who's also present here, is Rana Sami, and he's doing a project specifically on urban over-tourism, and the question if EU law is a facilitator or an impediment to effective regulation. So I think it would be immensely interesting if the 2 of you would be in touch. I really think there's a lot of links with or between your presentation and his research. One thing that I'm wondering about is, so in the Kali judgments case, and in your presentation as well, the focus is mostly on housing and the issue of affordable housing, access to housing. And I think it was to be expected that this would be accepted by the Court of Justice of the European Union, also based on previous case law, as a so-called overriding reason of public interest. I think there was little doubt that this would be acknowledged as such. In the Kali Apartments case, there was also a reference to the French Constitution, but this is protected by many national constitutions. Where I think it becomes a bit trickier is where cities or local authorities in general start regulating for more economic reasons. And I'm thinking of Bruges, which is a case study that I looked at and where I've also done some interview research. And in Bruges, for instance, what they're trying to counter is the monoculture when it comes to shopping. And when you look at how they're trying to do this, so first of all, they're trying to provide more stores in the city center, or they're trying to reserve space using urban planning law. They're trying to reserve space for stores that cater for locals rather than tourists. And secondly, and that's where it becomes especially tricky, they're trying to limit the number of souvenir shops that don't offer what they call authentic, locally produced souvenirs. So you understand why I feel that this becomes a bit trickier under EU law. But on the other hand, especially the first thing they're trying to do, so kind of provide space or reserve space for stores catering for locals, I do think this is something worth pursuing. We've seen the same issue, I think, in Venice, where people have been protesting because the number of shops for locals has gone down drastically. So Venice has become a city for tourists, not a city for its inhabitants, or at least that's what they're claiming. So what would your ideas be, or your projections about the court's view on this? To what extent would these types of reasons be accepted as overriding reasons of public interest? I'm not sure. I'm just wondering, because I don't really think we have much evidence right now in the case law on this question, but I'm curious what you think.
Thank you, Stephanie, for your very specific and expert question. Diane, do you have some thoughts or ideas about where to go?
I have some first thoughts, but maybe Carlo also wanted to chip in on the previous question, so maybe I can process it a bit more and respond. Otherwise, I can also immediately say something. So I'm not sure what is.
Well, I'm fine with just a very quick one as a reaction to what I think Isolde asked before about the co-evolution. I think that you can see, well, internal market entering sort of the local level, sort of creating an interlegality, right? So it is the local restrictions who give shape to EU law by being rediscussed at the well, first of all, the European Court of Justice, but it can be also more in the secondary, the creation of secondary legislation. And there you see like different actors rescaling their sort of negotiation process at different levels. Now, also what has been said before, I think we often understand like cities and the local level has been something, has been a place for democracy. I would wonder whether this is the case. I mean, for me, the city is a market. It's a marketplace ultimately, because if you look at it, if you look at the creation of the city, it is a market, right? And the way also you enter housing is also through this very unequal way that is, of course, like being readjusted by the exercise of police power, but the way this police power is being exercised at the local level is very much unequal, because it's ultimately made up of coalitions being working in negotiations, tensions, and conflicts in order to shape the regulatory framework. So it is not always the case that cities specifically are being meant as more democratic than other fora. But at the same time, what you see sometimes happening, and then coming to maybe the question about shops, because I think there had been some quite few cases, the Court of Justice, right? So including the about Spain, which I think connects to what Stephanie said in the case of Barcelona about the protection of small shops. That was still a limitation made based on spatial planning laws and the dimension of the shops being used. And then, of course, I mean that market is subject to the freedom of movement for sure under the service directive, and that of course means that limitations must be sort of connected to the objectives. So public administration had to be careful in the way they frame their objectives and the measures to achieve those. But maybe Dion has something in connection to that.
Yeah, thank you, Carl. Yeah, indeed, my answer would go into that direction. I was thinking first of the Visser Vastgoed case, which is about a very small town, Appingedam or so, here actually in the Netherlands. And the other case is indeed the Catalan hypermarket case. I think the case you were referring to, Carlo, about Barcelona, indeed, which I think in both cases, the local authorities wanted to protect in a way, yeah, the urban environment, defined in a way that there was a certain mix indeed of offerings of local shops, and that not everyone would go to, let's say, hypermarkets, that were down the highway, and the city center would be left empty. So this idea of how to shape an urban space, I think my assessment has been so far the court is being quite lenient, with this respect, giving shape to, allowing local authorities to give shape to what they perceive as a balanced urban environment. So when it comes to, however, restricting tourist shops, because there's the extra element, you could say, of the foreigner, the temporary visitor, which goes to the very core of free movement in a way. So that could be a different. My assessment is, and it's always never ask a lawyer, to predict, court cases. But if there is a judgment in the future, I do think if it's reasoned well, and again, this comes back from the Kali Apartments case as well. The court is very clear that if there is a justification and if local authorities have objective evidence to substantiate the challenge that is and the concerns that are being put forward, I think the court does give quite some leeway. But indeed, again, it has to be well argued. It has to be well backed up with objective evidence. And if so, I think a case could be made that it's very important for an urban environment to have a balance between tourist shops and you could say infrastructure supportive of local long-term residents. And why this is important, I think Venice is the clear example, indeed, in which I've never been in Venice. I've only heard the stories, but indeed, that basically the city center has become a space which is more like a theme park rather than indeed a space where people live. And in the long run, I think this is also very detrimental to the development of urban spaces in the EU as a whole, right? Because, yeah, anyway, I'm going into an answer. I do think that the Court of Justice will be lenient as long as these policies are clearly defined and indeed engage with the justification patterns of EU law. I think it is possible. Yeah.
Thank you very much for your answers. I don't know if you want to say one more thing each to wrap up, because I think we are getting to the end of the discussion, although I think we could probably dig into a few things more, but do you want to say a few last words? Maybe Laetitia.
Not really. Thank you very much, everyone, for the interesting presentations and discussion. There's nothing really more to say on my side, I think.
Thank you. Carlo?
No, not much. I mean, apart from the two other speakers, and very kind to participate. I don't know whether Dion wants to say.
Well, yeah, one of the things that just popped up in my mind is the following, that there are huge debates in all kind of like legal, in geographical literatures, in terms of sociology, let's say to talk about the issue of Airbnb. There's so much written by geographers on this issue, but the role of EU law they completely miss so far. There have been some references to the e-commerce directive, but only as a footnote. And I do think, as lawyers, as legal scholars, we might actually step up our game a bit, to actually show how law structures these kind of conflicts that they are studying, because they might miss out on some explanatory factors of how policy comes to be, right? That's just something I wanted to remark. And yeah, because there are huge explanations about, how policies have been shaped, in relationship to urban mobility, tourism, etc. But indeed, if certain issues related to EU law are not being taken into account, then they're missing out on something. I think it's just a call for, be a bit more active as EU lawyers, administrative lawyers, on the role of law in explaining the cause of events and indeed public policy making. So, yeah.
Yeah, thank you very much for what you just said. And unfortunately, Marie de Kock had to leave, but she is very much interested in that kind of discussions between different disciplines and geographers, urban planners, and these kind of things as well, because we noticed that in a range of local policies that we may need to involve a little bit more different disciplines to see exactly what we as lawyers, as you just said, can add to their approach, debate, and sometimes they just put the law a little bit outside their preview, and that's something that we could maybe try to engage a bit more. At the same time, I thought that your 3 presentations were really very interesting, because it's not just about the law, it's also about the interactions between economic law, European economic law in general, the intermarket competition law, and EU administrative law. And we see that there are kind of interfaces, that there's this kind of registration number, but what is it under administrative law properly, right? Is it an impediment to competitions and this kind of thing? So we could say what it is. So there are lots of questions about that, about the bans, the limit, the licensing. So I like also this kind of interplay between these 2 legal dimensions. So sorry to take a little bit more of your time, but I want to ask Mariolina if you want just to say a last word for wrapping up things.
Well, yeah, just to thank our speakers today, those who were online with us, and also to mention that we will be back in the new years with a new seminar, a new event of our dialogues, and yeah, follow us on LinkedIn, on other social media, and we will post soon the details which are still being ironed out of the forthcoming seminar. So back to you, Iseult.
Sorry. Yeah, sorry, just to say thank you very much also from my side. Thank you very much, Carol, for putting the panel together. And yes, let's meet again to go on with the discussions, probably. Thank you.
Thank you. Bye-bye.
Thank you very much, everyone.
Thanks.